What I need to explain first is what we call the honour and dishonour basis of the law. Anybody studied this before? A couple of people in the room? Rowan, I know you have. So, to be dishonourable, how you behave to be dishonourable is the two main ways are through silence, and the other one is through argument, or to argue. Your silence is consent. It's law. Okay? So if you're pulled over and a police officer makes certain statements to you and you remain silent, okay, you're consenting actually to what's being said and you've contracted. And if you argue, you're also dishonourable. So isn't it interesting that if a policeman ever, or police woman, either way, arrests you, what do they say? You have the right to remain silent. Anything you do say can and will be held against you in a court of law. So if you're silent, you consent, and if you do want to say something, you're arguing, and it's admissible. They've got you both ways, haven't they? The two ways to remain honourable are full acceptance. Yes, I was speeding. And here's the trump card, which is known as conditional acceptance. So if you fully accept the offer or the allegation, you're honourable. But you can also conditionally accept. I conditionally accept to pay the presentment that you've left on my windshield wiper for leaving my horseless chariot in the street somewhere too long, upon proof of claim that you have the right to do that. And we've got all sorts of letters written, a lot more detailed than that. So you are remaining honourable because you're conditionally accepting the offer that they've made to you. You can see a few confused faces. Silence is your consent and your acquiescence. Now, in law, it's 72 hours. So when they send you a statement or what we call a presentment, and you don't respond within 72 hours, you've contracted and you're in agreement. Isn't it interesting that whenever they send statements out, they say, please pay 7 days or 10 days or 14 days. As soon as you don't respond within 72 hours, then you've agreed and you've consented. Okay? You can reset the button on that by apologising. Can't you, Rowan?
Absolutely.
Yes. The Bible says you can be forgiven 7 times, 70 times, which is a lot. So you simply write and you say, I apologise humbly for my dishonour, and that pushes the reset button and you can start again. And people aren't aware of all this. There's people we know that go to court and every second sentence is, I humbly apologise and I seek the court's forgiveness. And they have to do it. It's interesting. Okay, so what we've done using the laws of estoppel and silence is we send time-sensitive documents. We notice them that they're time-sensitive documents, okay, and we respond to their presentments. And we do that through what we call a 4-step private administration process. Does the Bible not say go to your neighbour and try and settle? Not to argue, to go to your neighbour and try and settle. And so that's what you do. So this 4-step process is bits and pieces of quite a few processes that I've been studying over the last couple of years. And there is one process that Mark Patelik has been using called accepted for value and returned for value. And what they simply do then is they capture the document, they print across exactly that. We accept for value and return for value and authorise you to take the funds from my exemption account. Because I told you your birth certificate has been mortgaged and there's a what they call a set-off or an exemption account. You're authorising them with your birth certificate number, your tax file number and your Centrelink number to authorise them to take the funds out and clear the debt. He does ask for a proof of claim, and for me, I always sit with intuition and work out what feels right to me, and so I've put together a process that I have used where I don't feel they have the right to take the money again when you understand how they created it in the first place without a valid proof of claim. So the process that we use is a proof of claim. If I make a claim, do I have to be able to prove it if I go to court? Or can I go around making claims willy-nilly?
Prove it.
I've got to prove it, don't I? So that's all we ask them to do. So the first step of the process is we send them, if anybody's been in a legal battle before and somebody's making a claim against you, your lawyer will send a letter of request for further and better particulars so you know exactly what you're dealing with. And we do exactly the same. We send a letter of request for further and better particulars, and we accompany that with a hold harmless indemnity agreement. I'll get onto that in a second. So the letter of request is written in very legal format. We notice them that we are the principal, and we say things like, despite you addressing your statements and correspondence to some banking-created entity, juristic person, I, whoever you are, the living man, woman, wish to advise that I do not consent to being the surety, grantor, accommodation party for your bank or legal created fiction. Okay, and as indicated in the attached hold harmless indemnity agreement. So the hold harmless indemnity agreement notices then that you now have knowledge that a corporate you has been established, and you know you hold yourself not liable for anything that did without knowledge. It's an unrevealed, unconscionable contract. So that's this document here. Okay, which we authorise for you. Please do not construe this notice as my refusal to lawfully pay any lawful alleged debt. Okay, I conditionally accept your offer for me to pay an alleged debt upon proof of claim to the validity of same as set out in this notice. So you're supplying them here a demand notice. You're requesting this information. And some of the things that you'll ask for is a validation of the alleged debt in actual accounting. You show us where the money came from. Did it come from bank deposits? Show us in accounting where it came from. They must be transparent with this information. Verification of your claim against me, a sworn affidavit and hand-signed invoice in accordance with the Bills of Exchange Act. I'll explain a little bit more about that as we go through. A copy of the contract signed by both parties and therefore binding both parties. If they want to come to court, don't they need prima facie evidence? Don't they need evidence of a contract? Does anybody remember signing a contract for a credit card?
Yeah.
No? You do? Yeah. I'd love to see it. I'll give you $10,000 if you can show me a contract signed by the other party.
I'll give you $1 million if you've got a contract.
I'd give you, yeah.
No, I signed it.
Yeah, exactly, which is not a contract. You've made an offer. Sorry, they've made an offer to you. You've signed it. They've not even signed it on the other side. You will not find a contract signed by both parties. They have to be able to come to court under the Bills of Exchange Act with wet signature contracts. Now, anything that they've had, they've probably traded off on the derivatives market anyway. Never have we had anybody turn up to court with a copy of a contract. So we asked them a few other questions, and they've never answered them. We've done somewhere between 180 and 200 matters now. We've never, ever, ever had a response to those questions. So then we let them know that we hereby give them 10 days' notice to reply to this notice from the date with a notice sent using recorded post. All of our clients send things using registered mail, where the other side have to sign for it and you get a copy back acknowledging that they've received it. They're addressed to the CEO and to the head of collections. Okay? They're actually addressed to a being inside the institution. So we require that back from them and signed under your full commercial liability and penalties of perjury, assuring and promising me that all replies and details are true and correct and without deception, fraud or mischief. Your said failure to provide the aforementioned said document as requested within the 10 days from the date above to validate the alleged debt will constitute your agreement to the following terms. So when they don't respond within 72 hours, even though we give them 10 days, when they don't respond, we then let them know that these are now the terms of the agreement. And under the 72-hour rule, you will now have what's called a tacit agreement in place because they haven't responded. They've been silent, so they're consenting to what you're writing in here. One, that the alleged debt did not exist in the first place, or that the alleged debt has already been paid in full, and or three, any damages I suffer, you will be held culpable. Then there's a whole list of other things that we write that will, if we list it on a credit reference association, we'll be sending them an injury monies for not limited to $10,000 per account. That if they should they pursue this matter without proof of a valid claim, you and your firm, we note the CEO's name, will be liable for the amount equivalent to your unsubstantiated claim and triple damages. Okay, so we write a whole series of new claims out in response, and the last one is we notice them what the process is. You will be issued with a notice of fault, a notice of default, and a certificate of dishonour accompanied by an affidavit in support. So we notice them that if they don't respond, that's the process that we're going to take with them. Very, very transparent. We then go on and ask a whole heap of other questions. We download recent documents from the RBA site, letting them know that we understand there's only 2.83% of currency available in notes and coins. We also make references to the Currency Act. which actually says that no more than $20 a day can be paid with using the laws of the Currency Act. So how do they expect us to clear the debt paying more than $20? We notice them that if they come to our property, they're in breach of trespass laws, which the High Courts have ruled many, many times in the past, $187,000 fines. So we let them know of all that information. Okay. Out of, as I said, the 180 odd matters that we've sent, we've never had a response to any of those questions. We've had some letters back where they might say, we don't understand your template. Please don't use this template, it doesn't work. We'll see. Okay. So then after a period of 10 days, we then send them a notice of fault with an opportunity to cure. Okay, maybe they didn't get it, even though they've signed for it through the registered post. Perhaps they didn't get it. So we then send them a notice of fault saying that we sent a letter of request for further embedded particulars and a demand notice on such and such a date. Under the Bills of Exchange Act, the Evidence Act, the Crimes Act, the Criminal Code and Public Notaries Act, we will require you to respond. And if you don't, we give them another 10 days notice, then we'll issue you with a notice of default. Isn't that what the banks do to you when you don't pay the money? So all of these letters, just so you know, are signed by whoever's executing them and 2 witnesses, 2 good men, and the thumbprint goes in there to clearly demonstrate this is a live flesh and blood being executing these documents. Then we will go on and issue a notice of default with an opportunity to cure. Of course, we want them to be able to show up to be honourable, don't we? Because we're executing an honourable process here. So the notice of default and opportunity of cure is worded similarly to the notice of fault, letting them know that we wrote to them on a few occasions that we haven't heard back. We then issue the 4th step, which we do in the presence of a public notary, and I'll explain the importance of that in a second, on cotton paper, okay, which is of substance. All original deeds were printed on pigskin and cotton paper because it actually lasts 500 years plus. Okay, and the Bible says that documents ought to be written on cotton paper as well. So we do. Our clients write off to one of the only places we know of in Tasmania that supplies it. It's about $2 a sheet. It's not that easy to get through the printer, but we do. And we issue them with a certificate of dishonour, which lets them know that we've given them 3 opportunities to turn up to be honourable, and they've declined to do so. And through their silence, they're now in dishonour. And the document explains that quite clearly, that we wrote to them on this date, and so forth. If this is going to go to court, that's what the court system is based on. Yeah, absolutely. So again, that document is issued with your thumbprint. Again, it's with 2 good witnesses, and it's important that you have 2 witnesses. And then on this occasion, it's actually executed in the presence of a public notary. So on there will be his big red stamp that he presses down into the press, and he writes his information across it. And essentially what this does is takes the private process that you've executed and now makes it admissible in the public courts. Because you now have a public notary who's witnessing your execution of the certificate of dishonour, and not only the certificate of dishonour, the affidavit in support. I know we're getting into the technical stuff here, and people who are not technically minded might be all wishy-washy in the head with it. But if you're going to go to court or you want to follow the law, then you must do it excellently. So these letters have been very carefully drafted. You must be impeccable with the way where your names are in capital letters, the dates, certificates of mailing. Everything has a certificate of mailing, again with two witnesses, so there's a really strong paper trail, and that's super important if ever that has to go to court. It's also then issued with as I said here, an affidavit in support. Just so you know, in court, is hearsay admissible? No, the answer is no. So an affidavit is your first-hand personal knowledge of something happening. So the affidavit on your behalf is that you've written to these people, you've asked all of these questions, and to the best of your knowledge, you've had absolutely no response. And so you've executed this process. If they want to turn up to court, they must have an affidavit to rebut it, because an unrebutted affidavit will stand. And I believe that the use of the public notary and our affidavits and all the questions that we've asked has added weight to this process, because we've not had one client served. Out of 180 matters, we've had 2 clients listed, and I can tell you if those 180 matters had done nothing, they would have gone into default and been listed on CRAA or VEDA or whatever it's called now. We've had 2 clients listed. One was with Citibank, and that was, I believe, a mistake on behalf of Citibank. We had one case manager who was handling a lot of these cases. I'm not going to mention his name now. What happened was we had probably 30 or 40 matters coming for the 4th stage of execution, and that person left, mysteriously left. Now that person also was representing 2 other banks, the exact same name, representing 2 other banks as the head of collections pursuing this matter, and the signature was different on behalf of all banks. So we had a client ring up trying to speak to this particular person and got told from the bank, that person doesn't work here, we don't know who you're talking about. So Steph actually rang and got the same response, we don't know who that is. And Steph said, well, I'm holding a document from Citibank with this person's name on it, and there's some pretty strong allegations here, I'd like to speak to them about it. They put her on hold and they came back and said, oh, he's not in yet. And this was at 11:30 in the morning. And Steph said, well, could you put me through to his PA or voicemail? I'd like to leave a message. And they said, no problem, and hung up on her. Okay, and then the following week, that person no longer worked for the company, and there was a new person in there. We write, as I said, to the CEO and the head of collections, which means we're holding them commercially liable for anything that they want to respond in return, and it's them who we will be taking to court in the future.
Is it them you're holding responsible, or their person?
No, actually them. And it's interesting, when they write to you, they write in upper and lower case with their name, but when they write to the client, they write in uppercase. And that's one of the questions that we ask them.
Is this process good for, did you say, mortgages and credit card debt? Is any,
This
credit card debt?
This process is only good where money's been created out of nothing, as far as I'm concerned. It's because a lot of the questions we're asking them is, where did the money come from? See, if it came from depositors' funds, deposit means to set down. So if you deposited money in the bank, where did you authorise them to lend it out on your behalf? So where did the money come from? They've got no answer as to where the money came from other than they created it out of thin air. Okay? So this will only work where we are exposing that fraud, which is a fraud. Okay? They haven't got due consideration.
That's all financial institutions.
All financial institutions. Yeah. So only for credit cards, personal loans, car loans, mortgages, we've done the whole lot.
Store cards?
Store cards, yep.
Margin loans?
Pardon?
Margin loans?
Yeah, it's still, if they lent the money to you out of thin air, then plus there's no contract. Very rarely have we ever seen, we've never seen a contract from the other side, signed by the other side. So these are the questions that we're asking. Now, we don't want to use it where something has come back, where you've got something of substance. All right, I had one client who was a mechanic, and he wrote to me and he said, oh, Mark, I've got something to go to court now because, from Repco. And I said, oh, okay. I sat down and had a chat to him, and I said, so was it Repco Finance? He said, no, Repco. I said, well, what did you get? And he said, oh, carburettors. And I said, you can't do that. You're mixing fact with fiction. They actually gave you something that existed, and now you're trying to not pay it. Well, that's dishonourable. Okay, so we negotiated our way out of that. This is only where they've created money out of nothing.
So really, when it comes down, where do you draw a line in relation to people who have received wages or received money in kind for work? Like, what's the difference there? Is it simply because you go out and do something? Well, that money's come out of nowhere to pay for those goods, or to pay for that service.
I've lost you.
Well, like say for instance, they create that $10 billion debt.
Yep.
Some of that money goes to pay wages.
Yep.
So in actual fact, that was false money to begin with.
That's right. Every cent in creation. Where did it all come from? It's all come from debt.
So really, it's just complete. The whole thing is complete chaos.
Yep.
So there's really nothing for them to stand on. No leg for them to stand on at all.
I'm not here guaranteeing anything, guys. This is all pioneering stuff. Okay. All I can tell you is that out of the 180 matters that we've done, I don't know how many mortgages we've done now. I really should get Steph in for that because she actually does all the admin. The first mortgage we started in November last year. So it's been out of the 4th stage now for months and months and months. He's heard nothing. The guy who's doing our systems, Philip, I actually knew him 5 years ago when I was a filthy capitalist promoter. And I ran into him outside of my ex's place. And he said, what are you doing? And I was a bit reluctant to say. But he said, oh yeah, that's that debt elimination stuff. I did that 2 years ago. He did it on a $730,000 mortgage on his unit in Surface. He was at the last workshop for anyone that was here. And he's heard nothing. Nothing. He gets a few threatening letters in the first 6 to 8 weeks, which you respond to honourably, okay, saying you haven't answered our questions, and nothing. No statements, no nasty letters, nothing. And we've had that with all of our mortgages, and we've just taken on about another 15 in the last couple of weeks. No. No, they haven't zeroed the balance. This is the 5th stage. So we've got a 4th step now that, in our mind, what it's done is it's stopped them. They're stopping sending letters and for the most part, stopping sending statements as well. We're now in the process of putting together a 5th step, which might be using this exemption account, but for an amount that they can prove was truly their lender's risk. Okay, and there's been a couple of cases go through where they're using trust law and issuing documents as the grantor of the trust and collapsing the original trust and then authorising them to take money out of this exemption account. And there was one, I know it sounds crazy, there was one last week of a guy who's done this, and he had a $30,000 CBA loan zeroed, and I've seen the document myself. Okay, but for us, all we've had is the lending institutions not pursuing the matter. Okay, which to me, their silence is still consenting that there's something in here. Why wouldn't they be doing it? I mean, the first mortgage we did was $540,000. Nothing. We're hearing nothing.
They haven't zeroed it, but that person stopped making the payments with no penalty.
We don't know because he's not receiving anything from the bank. Nothing. Yes, all of our clients, or most of our clients, we suggest registered with Veda. I'll answer you in a sec. They are registered with Veda. Now, I think you can spend a certain amount and just get your current status, or you can spend a little bit extra, and they'll notify you if you're actually listed with anybody.
What's Veda?
It's a credit reference association. We've also got another letter that we've written in conjunction with Kevin Thompson. If anybody in the room knows Kevin Thompson, he's been teaching people about constitutional law. He's about 70 odd years of age, super cluey, and he's given us a simple letter and bullet point form that we're now writing in legal jargon to write to Veda and say, what right did you have to list? They haven't got any first-hand personal knowledge. It's all hearsay. They're in breach of privacy laws, all sorts of stuff. So with our 2 clients that have been listed, we're going to attempt that. Actually, Steph got listed too, because we did half. Steph had a lot of debt when she came and met me. We did half of the processes using this process, and the other half we just let run. All of the ones that we let run, she's been listed on. The others, she hasn't. So there's definitely something in here that's scaring them off from wanting to list people and pursue the matter.
Because the one I have with mortgages, because being an ex-banks themselves, they take security over the property.
Yep.
So then, if you go to try to sell the property, it comes up with, sorry, the bank owns the property basically.
Mm-hmm.
You've got to make sure that it's clear from them before you can sell it.
That's the process we're putting together now, is
Okay.
requesting
Clear
clear
that.
title.
Yeah.
Essentially, under fee simple, under the Constitution, a mortgage is separate to a title. When you buy that property, your name goes on the title. And so we're now requesting, whether you've done this process or not, we're now requesting that title back. A mortgage is a separate arrangement. So we'll let you know what happens with that. There's been some really good successes in America, so we're now just getting the appropriate laws here and that process together now. We're probably, I've got a guy who's just starting with us tomorrow, who's been studying this stuff for 15 years, and he's writing all those documents with a few others in what we call our Brains Trust. So essentially, the public notary, okay, just so you know the weight of a public notary, we've got a guy that we use down on the coast, and there's been a lot of notaries, so Rowan probably knows, there's a lot of notaries do this for a while and then they stop doing it. So whether they get a tap on the shoulder from the courts or whatever it is, they stop witnessing these documents. Our notary's a retired barrister, and he's pretty, how do I say? Ornery. Mate, he's just a real down-to-earth, awake now to the system, and I kind of think he's on our side. But first time I met him, I said, so Peter, what does it take to become a public notary? And he gave me this big speech, looking over his glass, or well, you have to have been in law for a certain amount of time, and you're appointed through the British Parliament by the Supreme Court here in Australia and so on, and you need 50 witnesses, sound character witnesses and so forth. And he'd already read all our letters, and so at the end of giving me this big spiel, he just looked over and he said, but you know it's all a wank anyway. They were his words. But look, he's read our documents with a lot of interest. He's pretty sure. He said himself, if he was the head of the legal department of a lending organisation, and he got this stuff, why would you pursue this when there's 999 other sheep out of 1,000 that are happy to acquiesce to somebody from a debt collector's company. So really, we had a meeting with our clients. We've got a lot of clients who've already done the 4 steps now. Many of them hear nothing. A couple of them get the odd letter here and there. But we had a meeting to let them know that we're putting together a 5th process to try and get closure. Because just having them go away is no closure. It's still nice, because I've got to tell you, a lot of the clients that have come to us were on the brink of bankruptcy, a lot of them. We've had people sit with Steph and say, I'm going to kill myself. We've had a few of them. We actually did have a guy kill himself just before he came to a workshop. Somebody came to one of my workshops 18 months ago and he was trying to get his friend along, ended up hanging himself because they were going to foreclose on his house. So look how much attachment he had to all this fiction. But the meeting that we had was to let people know that had done the 4 steps. There are 4 options that we see. The first is now pay your debt. If you're that worried about it and you want some closure, you can go and pay the debt. Nobody put their hand up for that one. The second is do nothing. Leave the status quo go. They're not hearing anything and they're happy, so let it go. The third is to now pursue them under your new agreement for 3 times the damages, because they've not responded here, so clearly they are at fault, and you now have a certificate of dishonour signed by a notary. So take them to court as the plaintiff. Okay, because they must answer the questions. You think you're innocent till proven guilty. When you're the defendant, you have to answer the questions. They'll have to answer all these questions. The CEO who will serve. So I've got a couple of clients who are pretty brave and said, yep, let's do it, let's do that. Or the 4th one is to send them a letter of demand requesting either the certificate of title back or clear title on the car or a 0 account. Then a letter of, a final notice with threatening legal action in it, not then take them to court as the plaintiff again. And the notary said from that stage, he said, mate, they'll want to settle. They won't want this in court. They'll want to just sit down and settle.
Do they continue on adding interest onto the capital?
You can't add interest on interest. Penalty interest is...
Because you've taken it into the process.
Well, you're exercising a willingness or a dispute.
So it's
and either way, they can't hold property as collateral while you're expressing.
The balance sheet that allegedly you owe.
What do you mean?
Well,
We're asking for a zero balance.
But don't they then do they continue adding the interest onto the balance that you're in debt to?
No, because we'll be asking for the 0 balance. What they do behind the scenes is no concern.
But they just don't continue sending a letter saying that this month you're another $2,000 and $5,000?
No.
Okay.
No, we haven't had that either with our clients. Most of them get no correspondence.
Okay.
Yeah.
So you would have to stop paying them, otherwise if you enact that process and you continue to pay them, you're in conflict.
Yes.
Yeah.
So you still accept the debt as being real if you keep paying?
Yeah.
You can't have 2 bob each way, obviously.
Yeah.
What's the average course of time for this to happen?
The minimum is about 33 days, because 23, isn't it? 10 days, then 3 days. But we always give them a little bit of extra time. It normally takes our clients 30 to 45 days to get to the 4th step. Okay, the 4th step is going to the public notary, and there's an extra fee for that. The guy that we've got, some notaries will charge you like $170 per seal, and there's 2 seals per debt, okay, because there's the certificate of dishonour and the affidavit.
Okay.
Our guy does it for $50 a matter, okay, because we're sending him a lot of clients. So that is a separate time that you'll have to have 2 witnesses with you, as well as the notary, and you'll have to get your own cotton paper. Okay. Look, it's a big test of your courage and faith to be able to actually really know who you are. We won't take a client on who just wants to write the debt off. This is as much, if not more, an internal process as an external process. We can help facilitate the external. I see Rowan nodding up there. He's had a lot to do with this. But unless you're prepared to really understand this process and watch the DVDs and read the books, then we're not prepared to take people on as a client. We don't take everyone on. Okay, this is not a get out of jail for free card.
And obviously you're out assisting them, like you would never go back into it.
I'm never going to go back into debt. Yeah. And do you know what? Normally I was saying at lunch, we've normally got about 25% of the people that come are old clients. We've had people come back 3 and 4 times just for the information, but it's really cool when they come because they can tell you, oh yeah, I got a few threatening letters and now I get nothing, and they explain their situation. You've got to start looking at this as fun. And a lot of our clients come to us honestly with slouch shoulders and this massive debt of fear of loss, of losing things, and within 3 or 4 months, they're just shoulders back, their complexion's back, they're happy and smiling and realising what the whole fiction that it was. We've done lots of cars. We had 1 car repossessed, okay, so we learnt from that. If you're going to do your car, swap it with someone for a while, okay. We've had repo guys come to the door and they'll knock on the door, mate, we're here to repossess the car. And so most people who don't know this knowledge go, oh, I'm bad, I'm wrong, I'm behind on my payments. They sign a surrender document and they give them the keys. I say, but we give you all the scripts on what to say, which is essentially they're trespassing. Okay, so some of our clients stick these signs up, especially if you're doing a mortgage. We'd request that you stick these up. This is private property, no trespass. Okay, and we quote Justice Michael Kirby here of the Australian High Court saying, no one, not even the Queen, could trespass or take property held in fee simple. It equates to theft. Fee simple is your clear title. Okay. So, and there are many case studies. There was one, Plenty versus Dillon. Dillon was a police officer who lost $187,000 for trespass. So you just notice some of that and they run away pretty quick every time. We've had quite a few of the people who have written off cars. The repo guys will come to the house. They'll come twice. And they see this and get told, you know, the script that our clients give them, and they leave. But this one client, we told him to swap his car. He didn't listen. He had a nice BMW. And they knew what his occupation was. He was a business coach. So they went online and they said, oh, we want to be a client. We're interested in being a client. Can you meet us at the Breakfast Creek Hotel? He lives on the Gold Coast, mind you. We'll meet you there at 12 o'clock. He drove there, 12:15. He's like, oh, I don't know what's happened. He went out to his car to get the client's number. Car gone. Right? When it's in a public place, they see if they had lawful title to that, couldn't they come and get it even from your home? They lured him through deceit. Who deceives? Lucifer. They lured him to a public car park and towed his car away. Now, it got taken away by Australian Repossessions, and it got taken to Fowles Auction House, which is one of the biggest auction places here. We've written to the repossession company, and every time they write back, so they understand the laws of silence, and they all write back going, we don't know. We've written to Fowles saying you're in possession of stolen property, and you know, a whole heap of other stuff. Fowles normally give you, or the finance company will give you 21 days to remedy, okay, or to fix cure the situation, or they sell the car. Well, that was 5 months ago, and the BMW is still in the Fowles car lot, never been put up for auction. So I don't think they've got a bit of a hot potato. They don't know what to do with it because they didn't have the right. These clients went down to the police station and tried to report it as stolen, and the police said it's a civil matter, nothing to do with us. We've got it all recorded. Okay.
Have you heard of John Wilson, the Commonwealth Rights Group?
No.
No? He's very big on all this mortgage.
Yeah. Well, the common law side of the court, or the equity side of the court, is where the fifth process will go, because we're going to then start entering into trust law. I don't want to get into that today. I can already see a few eyes going every which way, but we'll hold an advanced course, or I run through a lot of that if you want to undertake the process. But essentially the fifth process will be writing back as the grantor, issuing them as the trustee and ordering them to pay from your exemption account. Okay. So that's the debt process. There's a separate letter for debt collectors. We're now getting some of the institutions, I should get Steph wrong. Do you want to grab Steph? Do you mind? Steph handles a lot of the communication, but we get some funny letters back. Oh, just so you know too, a lot of the time when we've done the fourth process, the banks will write back to the client and go, okay, look, we just want to sit and talk. Will you be happy to settle for a certain amount? Citibank are coming back with roughly 60%. Okay, so they'll give you I always need you. I'm just talking about some of the letters that we get back from the bank. So Citibank have written back to quite a few clients. Like one particular client had a credit card for $12,800. They've written back saying, will you be happy to settle for $8,000? Steph herself got a letter 1 week from CBA? No, NAB. NAB. So the CBA is the Criminal Bank of Australia. There's Westpac of Thieves, NAB you every time. NAB wrote back and said, one week saying, we're going to take you to court, you know, this, X, Y, and Z, all these threats. And then the week after they wrote saying, as a valued customer, would you be happy to settle for 50%?
Well, before that though, it went from NAB to a debt collector, back to NAB to another debt collector, back to NAB to another debt collector. So there was 3 debt collectors in total for that one day. And then after all that, about you've now got 48 hours or we'll take you to court, blah, 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 blah. Which I was really scared about. And then they offered me 50% discount.
But then you're admitting that you're liable for that debt rather than trying to wipe the debt now.
Look, when I said the four steps, and like the public notary said, negotiation is going to probably be the best way through. So when we write back and threaten to take them to court, we're happy then to approach them and say, look, let's just sit and settle. And the offer that most of our clients are happy with is 10%, 10 cents in the dollar. Because we've asked them, you've mentioned lender's risk all through your contracts. Show me that through fractional reserve lending, your lender's risk isn't any more than 10%.
So
And if it isn't,
20,
yep. There's cases going through where they're getting...
you on the CRA?
As I said to you, out of about 180 matters, we've had 2 clients listed. One we think was a mistake. The other one, we actually haven't qualified that. She just got a letter saying we have listed you. We haven't actually got the VEDA report
Not that
back.
you wanted, because after you, I mean, you wouldn't want to go back into the
Yeah, look, that's not true. Some of our clients have, and then they've come back for us to write it off again, and I'm not interested, mate. Two wrongs don't make a right. So you're now with knowledge. If you're now with knowledge of the fraudulent system and you want to go and play, then you go and play. But if you want an honourable way to remedy the situation, then we can help you with that.
With the councils and that, I've had them actually tell me after not being able to pay the rates and that to a certain point, that they had the ad already lined up to go for auction my house and everything,
Yeah.
for $3,000 debt.
Yeah, they can't do that, mate. There's lots of stuff you can... Look, they're the master of threats and intimidation and fear, and you know, that'll only work if you allow it to work.
Contract. They did not,
That's
put a
right.
contract to you and say, would you like to enter into this contract where you pay us rates at the,
So council house rate, land rates,
Well, rates. I don't want to get into that today, guys. Let's stick to the debt. But you know, rates. If you're getting water and your garbage is being picked up, then it's honourable that you pay something for that. The rest of it, yeah, we've got some clients offering to pay for the certain breakdowns of the rates and not the rest, and they seem to be having some success with that. Where was I going to go? Debt collectors. If you lend me $50 and I don't give it back to you, can you then get this person to come and get my $50? No. What contract would I have with you? None. That's exactly what they do. Okay, so we've got a letter that we send back to debt collectors. It's actually Lee Hutton wrote the majority of that, if anyone knows Lee Hutton. And we send that back to them, and 90% of the time you'll never hear from it again. They'll either send it back to the bank or you'll just never hear from it again. A couple of them have now sent some stupid letters back to us, but you can understand this is just a game of cat and mouse, and they're always trying to say...
I'll be quick. Say you get 10 cents in the dollar, so you've got a home loan and it's now $20,000. What's the normal agreement on the time frame to pay that?
This is what we're just putting through now. So we're probably 3 or 4 weeks away from having that 5th stage. So that's really pioneering stuff there, mate. It's that's just what I would do. And again, I don't ever recommend what I would do, which is to offer 10 cents in the dollar.
Yeah.
Now, some of our clients say, well, I don't even have that, but there's plenty of places that will give you, you know, access to that sort of money if it's only 10 cents.
We probably already paid 10 cents for
Yeah, well, that's the reality is most people have already paid in excess of that.
Right.
So they've already got their money back.
and I'm sure you can negotiate a time frame anyway.
Yeah, well, that's what we'll be doing. So it's really exciting times, guys, for these matters. We've got lots of people with cars, like beautiful new Land Rovers that did this 9, 12 months ago, still driving around in their cars. They've had the repo guys there in the first month or so, never heard anything ever again. Just nothing. I mean, don't you find that interesting?
Are you both debt-free? Are you both debt-free?
Debt-free, absolutely. And we'll never be into debt again. And this is what I was going to say to you before. When you're out of debt, it's amazing how much more abundant you are. You don't have all that debt. All you now, go home tonight and see what if you didn't have to pay your debt. That's how I met Steph. My company, my financial planning company, was sending money to Kids Helpline, and we were doing golf days. And Kids Helpline and the head of Kids Helpline and Steph are good friends, and she sent Steph to me. And Steph lost her restaurant. She had a restaurant here in Brisbane that they didn't renew the lease on, and so, you know, it had only just started to turn the corner, but she's left with all this debt. And you had brunch with me, and I said, well, stop paying it. And it was like $4,000 to $6,000 a month that Steph was just paying in this overdraft and so forth for a restaurant that was gone. All money lent on credit.
Sorry, Mark, does that cover leases as well, did you say?
No, leases are different. Well, what was I going to say then? Now, some people have an issue with whether this is actually really honourable. Because I have a lot of people say to me, well, I did get a credit card and I did buy the goods and I'm now driving or using or wearing the goods. I'm feeling a bit dishonourable about that. Okay? The law, and really morally, to me, it comes back to the point of origin. Who committed the original fraud? They did. Why is everything so expensive? Does the Bible not say usury is a no-no? What's one of the only times Jesus lost his temper was in the temple with the money changers. The interest is what you just saw, and I can give you a heap of stuff to research this. Where do you think inflation comes from? Why do you think everything's so expensive? It's because of interest. You guys have got to get that basic concept. When they issue a certain amount of principal and there's an interest component to it, where does the interest come from? That's a really big concept. It can only come from issuing more principal, so they control the inflation. Everybody thinks, oh, the RBA, yeah, you know, they put rates up and down and they do control inflation. How do they control it? They control it so that it's just enough for you to keep on that treadmill, okay, to keep up with things, but not that it's so low that you can get off and start thinking about who you are and come to meetings like this. Everybody's working at their maximum capacity. And now mum's out working. You try and take mum out of the equation for any family that you know. It's not right. Kids are going off. Our neighbours, we live on 10 acres with a family. Their little one from the age of 3 months was going to daycare all day. Now that baby needs its mummy. It needs love. Look at the society we've built because we've created interest. Interest is illegal. You can't pay it. You can't be in servitude. But your straw man can, and you're acquiescing when you sign those documents. That's why everything's so expensive. Why do you think a house in Pacific Pines or whatever is $450,000? Where's a young couple going to get the money to buy a house to get ahead these days?
You need to mortgage your actual
And then they fill it full of stuff.
They try to actually use a mortgage that's generational, so you can actually get a mortgage now and pass it on the debt on to your kids if you're a certain age.
I want to get over that feeling of like you being dishonourable. I read Mary Croft, Mary Elizabeth Croft.
Oh, thanks for bringing that up. Yeah.
And I'm so over it now.
Yeah. Absolute.
She goes into in-depth.
Yeah. Absolute step one, guys. Just Google Mary Elizabeth Croft. She's got a book called How I Clobbered Every Cash Confiscatory Bureaucracy.
Darling, I've got recommended reads out there that's on there.
Okay. So, but that's the first thing you should be reading, about how everything's actually already been prepaid. And I didn't want to get into that today.
Yeah, because she says, she said it's all in the name, people. It's credit card. You're in credit, not debt.
Yeah.
It's not a debt card.
That's right.
And that got me over it.
Yeah. Everything's actually the opposite of what you think, but I've already got enough cross-eyeds in the room. It's an incredible concept. But what we're really excited, guys, about the 5th stage of the process and some of this trust law stuff that's coming out with people getting their account zero. There's nowhere for them to go, and it won't be heard in the public court. You'll be approaching the equity side of the court and for it to be heard in chambers, and they'll want to settle. They don't want this stuff getting out. They're already holding on, guys. The banks are in all sorts of trouble. Do you know how bad debts are at the moment? They're out of control. We deal with the real people. Every time they put interest rates up, I'm like, man, what are they doing? The average person out there is really hurting. And we deal with SMEs, which are small to medium enterprises, and they are funding their business with credit cards at the moment. I can tell you now the figure is not 10 or 20 or 30% down. What's the standard figure we're hearing? 80% down, a lot of SMEs. We've got people that had computer hardware and software companies supplying Retrovision, 80%. People in real estate, 80%. Restaurants, 80%. But their overheads are still up here, and they're overdrafts and credit cards, and that's how they're funding it. And there's many of them are just, they're done. Or they're on the brink of it. We know a commercial real estate agent in the Tweed area who out of his database or his client base has 15 or 20 ready to walk away.
Robert Kiyosaki, I can't remember which book, I don't think it was Rich Dad Poor Dad, it was one of the following ones, actually predicted this, I remember reading about 10 years ago. Yeah, you can't keep on printing money.
No.
Except the rich get richer, the poor get poorer.
Yeah.
But it's designed that way. So do you ask yourself why the banks do this? It's not really the banks, it's the Illuminatis who own the banks who are running the world. Why are they doing it? People say to me, well, why do they want to crash the economy?
It doesn't affect them.
It doesn't affect them. What's happened is through the Illuminati, the feudal lines, they want to keep the control and the power just in their bloodlines. There's actually a lot of mainstreamers now that have started making huge amounts of money. They want to pull the rug out from anybody, everybody. People in 1932 when the Depression came, 2 weeks earlier were in their top hats at cocktail parties and then in soup kitchens. Coming soon.
Well, that's what happened in 2008, same trip.
Yeah. It's all fiction. Look what's happened to everybody's superannuation policies. Because 92% of your super's on the share market. That's shares. I've shaved off 45% not so long ago. Does anybody have any questions?
were up on the Sunshine Coast, you said there were 6 countries that were not tied in with this. What others?
I think they were some of the Middle Eastern countries and the South American countries, and they're the ones that the presidents seem to get shot in and all that sort of stuff. So if you're interested in doing the debt work, just Steph will email you, or a foundation, Steph will email you after the event. We've got a bit of a waiting list of about 2 or 3 weeks at the moment, unfortunately, because we're just chock-a-block. But if you let Steph know, we can probably do foundations earlier, but the debt stuff, we just, I've got a waiting list at the moment. So if you just fill in the forms, they're pretty easy, and let us know how many debtors, creditors you've got. We ask for a donation of $19.70 to do the debts. That's up to 4 creditors. And then any creditors on top of that are $2.50 per creditor. A lot of people say, how am I going to get the money to do that? Well, just stop paying your credit cards and get the money pretty quick. Yep.
You have to stop using them too, though.
Yes, you have to stop using them.
It's a whole system.
Look, if you've got a foundation, you get a debit card. So if you ever need to buy stuff off eBay or travel or whatever, you can still have a debit card, but you've got to have the money in there, which is how it should be. With the mortgage is $2,470, and the foundations are $970. And if you want more than one foundation, because some of our clients have 6, because they've got restaurants and all sorts of different businesses. We've got 5, 4 or 5, 5. We've got them for different purposes. So we've got Truthology that we speak and trade through. Then we've got a philanthropic one. Then we've got one for holding assets and all that sort of stuff. If you want subsequent foundations, they're $770. If we go to the bank on the same day.
But you get the zero balance on the debt, and the title deed released. Does it get released to the strawman? Does it get released to the builder?
No, to the strawman's the only thing you can trade it. So you're still all going to be living in the public world until things change. It's just about knowing when you're acting in the public and when you're acting in the private, which you'll get to know the more you. Yeah. No, actually, nobody owns anything, guys. What are the 2 ways to buy property? Joint tenants and tenants in common. By the way, you're a tenant. They've told you. And the certificate of title that you get back, you won't get an original notarial deed. They've all disappeared off to Switzerland. You'll get a computer-generated certificate of title, which actually states in there it's owned by the Crown. They can take it off you any time they like.
Apparently the Queen owns.
Can I pay by credit card?
Can you pay us by credit card? Yeah.
Okay.
How's the serenity? How's the irony? We don't take promissory notes.